Against the background of the recent Workers' Day celebrations, we focus on the labor laws and the agitations for better wages. We have the opinions of some lawyers on the issue. On our interview segment, a foremost legal practitioner on employment, labor and industrial relations, Chief Gani Adetola-Kaseem SAN, is our guest. Hello and welcome to the program. I am Shola Shoyeli. One of the arguments trailing the last Labor Day celebrations is that the country's labor laws favor the employers to the detriment of the employees. Some workers think that there is a need for certain reforms in the laws and industrial relations generally. I spoke to some legal practitioners to get their views on these issues.
Most employees generally, they can either take benefit under the provisions of the labor law, the Labor Act, or the Workmen's Compensation Act. But with regard to the majority of employees, the vast majority of them, their employment are controlled by private contracts with their private organization. So the primary document that protects them is their contract of employment. So it is whatever is contained in that contract of employment that protects them. It is only those in public engagement. Those are the ones who have some form of protection. But those who are outside public employment, their protection is either their private employment or the benefit of collective bargaining, which can be obtained through the unions that get certain conditions for them and ensure that those conditions are upheld. So where there are no unions, obviously it means that the employees are completely at the mercy of the employer and whatever those terms are, because really at the back of all of this is that employment is a personal, private arrangement. We call it a contract with a personal flavor. It's private, it's personal. If the employer doesn't like the employee, there is no court of law ordinary that will enforce an employee on an employer, except where that contract has a statute protecting it.
In instances where the contract of employment specifically mentions some items requiring the governance of that particular employment, and if the employer is in breach of a particular term, to take necessary steps requires that the employee goes to court. Now, going to court where he earns little or nothing, how can he achieve that? How can he enforce his right? There is right, actually. But how can you now approach the court to say, this is my right, that has been infringed upon? So what can I do to do it? You discover that he cannot engage the service of a lawyer. He cannot come out to the open court because there are procedures. He filed action to say, okay, I have not been paid for 6 months, or I have been abused, this thing has been done, or there is a particular breach, a clause in the contract of employment that has been breached. Of course, to enforce it is coming to court, and it's difficult, and it takes time to do that.
Recently, the Minister for Finance came forward to say they discovered 23,000 ghost workers. I've not heard a word from Labour on it. It's an important factor. Do you know how much goes to 23,000 ghost workers annually, annually? Labour did not agitate for that. Are we moving the nation forward? So, in order to address these kind of issues, my view is that Labour, both at the state level and at the federal, should meet with the government. Please come forward with your specific economic policies. This is our view. Recently, there was agitation for economic summit. What was taken away from that summit? The next one to be held, what is going to be taken from there? In what way has Labour met with government in saying, look, this policy is unfriendly, this is friendly? I will expect Labour to rather negotiate more for benefits.
Presently, the law as of today is that any issue determined by the National Industrial Court is the final court. The decisions are not appealable except on the ground of fair hearing. I want a station where our laws can be amended such that final decisions of National Industrial Court at least get to the Court of Appeal. The National Industrial Court should not be the last court. It's like a man sitting over a case and his decision is final. I feel that the law should be amended in that regard. At least take it one step further to the Court of Appeal. Any decision by the Court of Appeal should still go to Court of Appeal, not only on fair hearing matter, but on all the matters. Because you can't expect a judge to decide an issue and you want to tell me the other party doesn't have an opportunity to appeal. to a large extent, that can work injustice, and it's been working injustice. So I will appeal that the law should be amended such that decisions of the National Industrial Court as the first court, that's the court of first instance for employment, labor relation matters, should not be final. It should get to at least Court of Appeal.
It's time now to do a quick recap of some of the top legal stories from the courts.
We begin with the report that the registered trustees of the Socio-Economic Rights and Accountability Project have asked the Economic Community of West African States Court, that's the ECOWAS Court in Abuja, to hold the federal government responsible for various violent incidents across the country leading to the loss of property and human lives. They also accuse the federal government of permitting human rights violations in the form of killings, rapings and maimings of citizens by violent headsmen, military and police operatives.
Should be supported.
Serap's counsel, Mr. Femi Falana, who filed the suit on behalf of his client on Tuesday, claims that the alleged failure of the federal government to do due diligence in preventing, investigating and prosecuting cases of rights abuses had occasioned the breach of the African Charter on Human and People's Rights and the International Covenant on Civil and Political Rights. For these breaches, Serap urged the ECOWAS court to make an order compelling the federal government to wake up to its responsibilities and fulfill its obligations of securing the lives and properties of its citizens. Serap also wants the ECOWAS court to compel the federal government to pay 50 million naira compensation to the dependents of each of the victims of violent killings by violent headsmen and brutal police and military operatives. The authorities of the Nigerian Army have convened a special court-martial to try two senior officers of the service, Major General Ibrahim Sani and Major General Patrick Falola. The convening order for the court-martial was reportedly signed by the Chief of Army Staff, Lieutenant General Tukur Buratai. The two generals are accused of offences bordering on service discipline. The specific details of the offences are, however, not yet known, as the military authorities are yet to draft the charges for which the officers were brought to the court last week Thursday. The president of the court, Air Vice Marshal Boom, has assured the parties that the trial would not be delayed in the interest of justice. He also directed the prosecution to serve the necessary documents on the accused persons or their defense team at least 24 hours before their arraignment in accordance with the constitutional provisions. The Court of Appeal sitting in Abuja has reserved judgment in the appeal by the National Publicity Secretary of the People's Democratic Party, Olisa Metu. After hearing the appeal last week Thursday, a three-man panel of the appeal court led by Justice Abdul Aboki said the date of judgment would be communicated to parties through their lawyers. A trial judge, Justice Okonabang of the Federal High Court in Abuja, had in his ruling dismissed a no-case submission and ordered Mr. Metu and his company, Destra Investment Limited, to enter their defense. The EFCC is prosecuting Metu and his company before Justice Abang on charges of money laundering and alleged fraudulent receipt of funds from the Office of the National Security Advisor. In another case, the same panel of the appeal court also reserved judgment in the case of the self-acclaimed leader of the indigenous people of Biafra, Mr. Nnamdi Kanu, and his co-accused. They are challenging the ruling of Justice John Soho of the Federal High Court, Abuja. Justice Soho had agreed to the prosecution's request to shield the identities of witnesses in the trial. Nnamdi Kanu and his co-accused are contending in the appeal that Justice Soho's ruling on the 7th of March amounts to reversing himself, as he had earlier, on February 19, refused the prosecution's request for witness protection. And we round off with the report that a three-member panel of the Lagos Division of the Court of Appeal adjourned last week Tuesday to allow a full five-member panel hear the appeal challenging the ban on the wearing of hijab in primary and secondary schools in Lagos State. Justice Amina Ogi, who led the three-man panel, told the applicants, two 15-year-old girls and the registered trustees of the Muslim Society of Nigeria that the matter was a constitutional one. Justice Amina Ogi, in her response to an observation by the applicant's counsel, Chief Gani Adetola-Kaseem, said it is also a very sensitive matter that would most likely still get to the Supreme Court. According to her, all three justices of the panel were Muslims, and if they went ahead to hear their appeal, it would raise issues of bias. The court then directed the applicants to write to the President of the Court of Appeal for a five-man panel to be appointed to hear their appeal.